pipeline for more than a decade. Over 1,400 sections and 25 parts. That's the Companies Act 2014. It's both a consolidation of existing Companies Acts from 1963 to 2013, more than 13 statutory instruments, but it's also a reforming act. It'll introduce reforms such as mergers and divisions, the ability to have one director companies, the ability for directors to hide their residential addresses, and as I mentioned, will also consolidate existing legislation. I think the main thing clients need to be concerned about and firstly aware of is that once the Companies Act is commenced, there is an 18-month transitional period. Within that 18-month transitional period, clients are going to have to decide what type of private company they want to be. There are two types. One will be known as an LTD, one will be known as a designated activity company or a DAC. What's the difference between the two? The LTD will have the same capacity as a person, therefore can do anything that a person can do, whereas a designated activity company will be restricted by its objects clause. They should also review their existing constitution to determine what they want in their new constitution when they decide what type of private company they're going to be. Clients need to continue to comply with the Companies Act and be aware that the enforcer, the Director of Corporate Enforcement, the Companies Registration Office are always in the background and will be, as they currently do, actively enforcing company law.
Well, over the past 2 years, the office has refocused its enforcement on more serious breaches of company law, getting into the area of fraud. The challenges are manifold. First of all, there's a basic resource and a numbers challenge. Now we're hoping to deal with that by recruiting additional investigative accountants later in the year and releasing some of our Anglo investigation staff. I wouldn't underestimate either the fact that this is a timescale challenge for the office too, because in the past, where we would have worked on summary cases, they would have got into court within a year or two. These are going to be multi-year investigations. When we're investigating these higher level sorts of offences, it's not just company law. There's a multiplicity of breaches in there. So it's ourselves, it's the Garda Bureau of Fraud Investigation, it may be the Revenue Commissioners, maybe the central bank if there's a financial institution involved. And those multi-regulator type offences are a challenge for us. They're a challenge for the Director of Public Prosecutions ultimately when they get a file. And they're the sorts of things that we are now dealing with on a day-to-day basis.
Is there anything else that clients should know? I think that they need to continue to comply with company law as they're doing now. The Act makes it a lot easier to enforce company law, and as long as they continue to do that, there shouldn't be any issues. For anything else, because it's both a consolidation and a reforming act, because it introduces some new provisions, I think they should take appropriate advice before proceeding to go down a particular route.
For more information on the Companies Act 2014 and what it means for your business, contact Salvador Nash or visit kpmg.ie/Companies Act.